Hey folks, we have some critical information here today about state courts, something we usually don't think about or talk about, but we're going to today with a very prestigious, important guest, Carrie Severino. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, Second Amendment attorney, constitutional attorney, best-selling author, and proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay, folks, we have a very special segment here today. We're interviewing a very famous and prominent attorney, Carrie Severino, who I'm sure you've seen repeatedly on shows on the Fox News Channel, CNN, and Newsmax, and on and on and on and on. Carrie is a former law clerk to one of our favorite justices of all time, Justice Clarence Thomas, who wrote, of course, the Nyserpa versus Bruin case, which everyone on this channel is well aware of. Carrie is the president of the Judicial Crisis Network. She's also a best-selling author, along with Molly Hemingway, of a prominent book. I'm sure you saw her making the rounds about a year ago, Justice on Trial, the Kavanaugh Confirmation, and the Future of the Court. We'll ask her a couple questions about that as well. But most importantly, we want to talk to Carrie about something she is a true expert in, which is state courts and how state courts actively, importantly affect various constitutional rights, including your right to keep and bear arms. I mean, we talk all the time about federal courts. We talk about the United States Supreme Court. We talk about Justice Scalia and Justice Thomas and Justice Barrett. And often we talk about federal courts involving whether or not they enforce the Second Amendment in the lower courts, for example. But what we don't spend a lot of time on are state courts. And remember, we have 50 states, and each one of those states have court systems, and each one of them has a state Supreme Court. And the reason why I wanted to bring Carrie on to talk about this issue is sometimes you see this weird disconnect. On the one hand, in the true blue states, as we like to call them, places like California and New York, we see, of course, that whenever there's a gun control law or some other law that liberals like, guess what happens? The state Supreme Courts in those blue states seem to always uphold them. They never seem to deviate. But then we have this weird confluence of events, this sort of weird difference, which is you have so-called red states, states that you might think are more Republican or more conservative oriented, places like Indiana, places like Montana, and then all of a sudden you get these kind of sort of what I consider liberal outcome decisions from the state courts in places like Montana and places like Indiana. And I was trying to understand, why is there this disconnect? What's going on here? Can anyone explain this? So I wanted to bring Carrie on to talk about this, to tell us and teach us a little bit about the state court systems, how judges are picked at the state courts, how it differs from the federal system, and anything else we ought to know for those of us out there that really want to be the smartest person in the room when it comes to the Second Amendment right to keep and bear arms, whether it be protected by our legislators, by our Supreme Court, or by state courts. So Carrie, welcome aboard and welcome to the Four Boxes Diner.
Thanks so much for having me. It's great to be here.
Great. So, Carrie, I'll start right off at the top. So whenever we talk on Fox News, we seem to inevitably talk about the federal courts, whether it be Judge Kavanaugh, Justice Barrett, what the Supreme Court's doing. But often it gets neglected that we have 50 state court systems out there in the United States as well. So tell us a little bit about what are these state court systems and what do people need to know about them?
Yeah, you know, it's true. It makes kind of sense, especially when nowadays so much of the news is national that we're watching. Of course, we focus in the U.S. Supreme Court, and that's not wrong to look at that. They obviously are the Supreme Court, the highest law in the land, and they're making decisions that affect the entire country. But we shouldn't focus in the federal courts to the exclusion of remembering that we have 50 state courts, the local courts in the District of Columbia and all the territories that are actually making also incredibly important decisions. 90% of the cases that are filed are actually filed in state, not federal court. You actually have to meet certain qualifications to be in a federal court case, but most of the cases you think of are actually dealt with in state court. And not paying attention to it means that sometimes we have judges in those state courts that might actually not be lining up with the way we think people should be interpreting the Constitution. There has been a lot of work done over the last several decades to try to make sure that our federal judges are interpreting federal law, and particularly the Constitution, in line with what it actually says, what the text of the words of the amendment say, what that was originally understood to mean, not what some judge today thinks, well, I kind of think that liberty should mean this, or I wish it meant that. That's not how we look at it. We look at what it says. So that we are seeing an era of a lot of success in that front in the federal courts. And the Bruin decision you talked about is a key example. We've got a Supreme Court, majority of the judges in that court are actually looking at the Constitution's words for what they actually mean and not trying to invent new things, just saying, let's read the Constitution as written. At your state level, that may or may not be the case. So each state has different methods of choosing its judges, and in a lot of times that can result in your state court looking different than you think it might, given the nature of the actual state itself. So you might have a state court in a red state or in a purple state where the state Supreme Court is in fact very blue, and like, wait, what just happened here? And there's a lot of different things that can lead to that kind of situation. But I think that's going to be an area that we need to start focusing on, because some states have judges that are chosen in ways that are similar to the federal court, where you might have the governor appointing someone and they may or may not need Senate confirmation, something like the federal system. Sometimes you have a governor that has a lot of leeway to just appoint the person. And if that's the case in your state, you should be making sure that, hey, when I'm thinking about who I want to vote for governor, just like when you think about it for president, you want someone who has a sound understanding of judicial philosophy, the governor as well. In some cases, you can actually have a state where they elect their judges. And some states are partisan elections, some are nonpartisan elections. But that's something that often you get ballot roll-off. By the time you're at the bottom, you're like, who even are these guys? You need to educate yourselves about who is running for my state Supreme Court. They're making really important decisions. They always have, and I think even more so now, especially, and I think we're getting a spotlight on it because of the Dobbs decision overturning Roe, because now a lot of state courts might be in a position where they say, hey, the federal court doesn't recognize a federal constitutional right to abortion, but maybe we'll just read that into our state constitution. No states have an explicit right, but maybe they'll have state courts that want to read it in. And they can do the same thing with Second Amendment rights as well, saying, hey, our state doesn't speak to it. Here's what we're going to make up our own area in this law. So you have to be educated about the people running for those state Supreme Courts. And then finally, one method, which I think is very misleading because it gets called merit selection. It gives you the idea that they're just looking and seeing who's the smartest guy out there, and we'll put them on the state Supreme Court.
Carrie, you had mentioned this notion of a merit-based system. That sounds to me, correct me if I'm wrong, but it sounds to me almost like a euphemism to let state lawyers pick the judges that they want to sit on the Supreme Court of their state or on the courts of their state, and they don't really want we the people to have a say. Is that what goes on in these places, or is it something different?
Yeah, I think these systems started because people thought, well, gosh, we don't want politics involved in the courts, and we don't want to elect judges, and however politicians do it. Let's just have a nice neutral system. But their neutral system is let the lawyers pick the judges. Well, look, folks, the lawyers are way to the left of where you are in most states. And what it really does is makes these courts be not accountable to the people anymore. So you have a commission that's generally made of a majority of lawyers, again, that aren't really accountable to anyone. You don't know probably who the lawyers are on your state's judicial selection committee, if you have one. They pick a panel of maybe 2 or 3 lawyers that they say, well, these guys are the guys with a lot of merit. Well, we know how this goes. The ABA does the same thing. They say we're going to rate the federal judicial nominees based on their merit. And we know that when you studied it, they rate conservative nominees and actually women and minority nominees consistently lower than everyone else. So these kinds of are facially neutral systems, they're not in practice. And there have been a lot of research and empirical research done to show that. It's what it really does is takes the accountability out of the system. So if you have a state court that isn't following the text of the law as written, that's not following the text of your state constitution, you don't really have an easy way to address that. A lot of these judges do have what's called retention elections, where you just have an up or down vote. Those don't really work very well as elections because 6% of the time, people just get reelected. It's not really a check. What I think works best and empirically is shown to be much more accountable is systems where you have some check where the people either elect the governor who gets to have a say in it or can actually directly elect the members of the courts themselves.
So, Carrie, I want to say it's something like 37 or 38 states have some form of judicial elections. Mm-hmm. what are the benefits? But in some of these states, I'm told that they can't have like advertising, or advertising is limit for these things. It seems like that's like trying to deny the American people information that they need to make critical decisions at the ballot box. So what is the story with these judicial elections? And are there any restrictions on, like, judicial advertising to talk about records and discuss and compare and contrast like you have in any other political election in the United States?
Yes, so 21 states have elections. Some of them are partisan, some of them are nonpartisan, but it does create challenges because you don't want someone who, you obviously don't want someone who has a case before a judge to be able to lobby for or against that judge in the election. And it makes it challenging because the judges aren't really politicians. They don't want to be you can't take a position, just like we get frustrated in federal judicial nominations hearings. Like, they can't say, I'm going to vote this way on this case. That's prejudging a case, and that's contrary to the judicial role. But it is important to be able to have that check at the same time. So you often do run into complicated questions. But these are races where I think what more often happens is there are outside groups who are concerned about making sure that you have judges, again, faithful to the rule of law, or maybe judges that are faithful to a particular interest group who might then be the ones doing the advertising. It's one of the reasons that, kind of counterintuitively, sometimes partisan elections actually have less of that, because if you have the party doing some of that upfront screening to make sure you have candidates who do have a solid judicial philosophy, that's conveying a lot of information right there. You don't need to spend a lot of money to run ads to say, well, this judge has this philosophy and you should vote for him or her. And so that does play a helpful role in some of the state elections.
So, Carrie, let me just ask a general question about constitutional law. You indicated earlier that state courts sometimes can provide greater individual rights protections than even the federal system. Is that true? And if so, can you tell us how that works?
Well, it can work in a lot of different ways. One is every state has its own constitution. So your state constitution might actually say things that are different, that are more protective of different rights than the federal constitution itself does. And so state courts, when they're interpreting that constitution, may then be able to afford more protection than the federal constitution itself does. That would be the legitimate way to do it. And same thing goes for state law. You could have state laws that are very protective, or counter on the other side, not as protective of your individual rights. One way that we have to make sure we avoid is state courts that are basically making up protections of one sort or another without having a real basis in their state law and their state constitution. That said, it's a little bit more, the law on this is a little fuzzier when it comes to state courts, because the federal system doesn't have something we call common law. This is the idea of judges sort of developing law over history. The image was always like an oak tree grows out of an acorn. You have a law, and then judges building on it and developing that law, hopefully not making a break with it. Judges really are never in any system authorized to just say, actually, I don't like this, let's go somewhere else, but developing the law that was already there. State courts do have a role in doing this. This is another reason it makes so much sense for state judges to have that accountability to the people, because there may be cases where they are saying, hey, you know what, the state statute, there's holes that it leaves here, it doesn't address this issue. There could be a legitimate role for state courts to then say, to kind of fill in those gaps that there isn't in the federal system. That's why we want state judges to really actually be at the same understanding of where they want the law to be as the people of that state.
I see. We sometimes talk on this channel, Carrie, about the differences, and this is a generality. It doesn't always hold true, of course. Nothing's 100%. But we sometimes talk about the difference between sheriffs who are elected on a countywide basis and their general respect for the Second Amendment's right to keep and bear arms. Again, not always, but generally speaking, we find that sheriffs that are elected by we the people in counties tend to be very sympathetic to Second Amendment right to keep and bear arms. In contrast, you see, for example, big city police chiefs that are W-2 employees appointed by usually anti-gun mayors in these big cities, the big top 10 cities of the United States. And of course, the big city police chiefs just always want more gun control like their big city mayors do. So, we talk about this a little bit. But what's interesting, Carrie, in terms of that is, when I do reading in this space, it seems to me that a lot of people that are on the political left side of the spectrum, they really prefer to have appointments. they seem to really like the idea of the mayor picking who's going to be the court, or specialists picking the court. They seem to be very much against judicial elections. Just like they want to be able to pick the police chief, they don't want to have we the people elections for sheriffs. It seems like a lot of this is the same thing with judges. A lot of people on the left side of the spectrum want to be able to pick who sits on those courts and not have elections. Is that the sense that you've had, Carrie, in studying this issue, or do you have a different take on it?
Oh, that's definitely the groups that are advocating for more and more of this, choosing by committee are, just down the line. They're groups on the left, and I think you're right. It's because what that is, again, it's one of these things that if you said to someone as well, which is, there's a neutral question, is it political whether you have a appointment or an election for a sheriff? People wouldn't necessarily know that that's going to produce a different political result, but in practice it does. I think people realize this on the judicial level as well. It's a very similar type of thing, and you kind of have to ask people who are trying to say, let's not have the elections, what are you afraid of? What kind of judges are you afraid of the people electing? And I think some of it is also just goes to an instinctual kind of rule by elite idea of, look, we can't trust the people of the states to actually make these big decisions about who their judges are going to be. And I think you really can. I think the American people are better educated and better able to make these decisions than a lot of our ruling elites like to think. And if we weren't, why are we living in a representative democracy? I mean, we're making these decisions. That's how our system is designed. It gives a lot of trust to the American people to say, we trust you to govern yourselves. And I think we should be able to do that in the judicial sphere as well. And interestingly, a lot of the early states, like the colonies, when they became states, purposely went to an election system because they were inherently very distrustful of systems like the British Crown, where you had just the king appointed governor who was then placing all the judges, who then all were just loyal more to him than they were to the citizens. And so that was actually part of the revolutionary ideal, actually, was having this ability to choose your own judges, much like we say you want a jury of your peers. They actually wanted to make sure you had judges that were accountable to the citizenry as well.
Yeah, actually, that's quite fascinating. I had not made that connection, Carrie. Thank you for that. That's wonderful. And again, we're with Carrie Severino, prominent best-selling author, as well as with the Judicial Crisis Network, an expert in judicial selection and judges, and a former law clerk to Justice Clarence Thomas. So, Carrie, it's interesting you bring up the jury system, because that is kind of unique here with it. The notion of our founding fathers said, we want you to be judged by a jury of your peers. We want it to be very democratic. We want other people to make decisions about you. We don't want it to come top-down hierarchical where, the king tells his minions, you do this, and then they do it. You raise a good point. So in some ways, I guess, judicial elections are a lot more like letting jurors make decisions about the law and not just letting the king.
Yeah, which at its surface is really scary, right? You're like, oh my gosh, who are these random 12 people who are making these decisions? But I think if you talk to people who've been on a jury, they realize that you have to really, people take it really seriously. And I think that is a great aspect of our system. And obviously, I don't think we should pick judges randomly like we do jurors. It requires a lot more legal analysis because you're not just making these fact-based determinations, you're making the legal determinations as well. But we still need to remember they need to represent the people as well, and not just some elites from on high who think they know better about how we are to govern ourselves.
So, Carrie, if people watching this video are interested in because a lot of people that watch this channel are really interested in protecting their right to keep and bear arms, as well as all their constitutional rights. They're very concerned about being told what to do. One of the themes of this channel, Carrie, is that we want to be American citizens. We don't want to be American serfs. We don't want to be American subjects. We want to be citizens, and the right to vote, the right to have property, and the right to have firearms is all part of what makes up a citizen and not a subject. So if given the opportunity to talk to the people on this channel, Carrie, what sorts of information in terms of what they can do or what should they do to learn more about the importance of the state court systems and what role maybe they play in it? Because I think a lot of people are out there like, hey, I'm a truck driver, I'm a plumber, I'm a teacher. I'm not a politician. I'm not a lawyer. I don't even know what to do or think about when it comes to picking judges because, it's not my industry. It's not my field. So what guidance would you give to people who are watching this channel about how to think about state court elections, state court judging?
I think the first thing is to do some research and figure out how are your state judges selected. If your judges are selected in elections, that means that's something, and I have to say, I I didn't really take this seriously for a long time. It was kind of like you get down there and you're like, oh my gosh, I don't know anything about these. But that's an area you need to educate yourself on before you go to vote. So, check and see, do you have people that in your state that are on the ballot this November? And there are some states where there's some really important elections. Michigan, I think I have them written down somewhere, but Michigan, for example, the balance of the court, which now is to the left, could switch this year. There are other states as well, and if I can find my list, but where educate yourself about that, because that will have a real impact on how your laws are interpreted. If you have a state where the governor chooses it, make sure that that's something, if your gubernatorial candidates are coming to a town hall, ask them about what their judicial philosophy is. If they don't think it's an important part of their job as a governor, they're not going to take it as seriously. We saw this for a long time with presidential candidates. They weren't thinking that who you pick to put on the Supreme Court is that important. So you had people like Eisenhower and Nixon who put some of the most liberal justices in American history on the courts, Republican presidents, because they weren't seeing it as, this is part of my job, I need to find someone with a solid judicial philosophy. They were like, hey, this is a political thing. It's kind of like giving someone an ambassadorship, like, oh, I'll give him the Supreme, this is why Earl Warren, the most liberal Supreme Court justice maybe in history, was Chief Justice, not because everyone thought, oh, here's a guy who has a great solid judicial philosophy. It's because Eisenhower wanted to give him political favor. That's a stupid reason to pick a justice. We need to make sure our governors realize that as well. This isn't your chance to appoint your law school roommate. This isn't your chance to give a gimme to some big donor and whose kid wants to be on the Supreme Court. This is your opportunity to shape the direction your state is going to go. And a lot of governors, it takes them a few years to recognize the significance. Even Ronald Reagan, one of the reasons he was so committed when he became president to appointing good judges is because he had experienced as governor of California the fact that, and Raleigh and I write about this in Justice on Trial, the fact that when he would pass good things, he'd pass a great welfare reform bill, and then the courts would overturn it. Every time he passed a really good legislative initiative, the courts would then just overturn it. Same thing happened in Florida when Jeb Bush realized the Florida Supreme Court's out to lunch in 2000 when they thought they could pick the president of the United States in Bush versus Gore. He's like, wow, these people have been saying it before, but it wasn't when that happened. He's like, you are right. These courts are out of control. They think they have the authority to just rewrite the law. And Florida, in the process, changed their system of selection so that now the governor actually has the authority to pick people. That has dramatically shifted their courts. They were one of the worst states in the country to litigate in before. Now they're one of the best, really solid. So there is room, if you can convey to your governor or to candidates, we need to focus on that. I think that's going to be very educational for them. And if you have a state where there's a Missouri plan selection, where it's just a committee that's doing this. There's a lot of states that have tried to shift that and tried to pare that back. Make sure that you find out, hey, maybe there's a constitutional amendment that is active in your state that you need to talk to your legislator about and say, hey, you should vote to switch that to a more accountable system. But the challenge is, there's 50 different versions, so I can't tell you what's up in your state. That's something that each person has to go and figure out where you fall on that so that we can, just like we've learned that we have to hold our members of the U.S. Congress accountable, our state legislatures accountable, we realize we have to actually hold our state judiciary, and particularly in how they're selected, we have to hold that accountable as well.
Well, Carrie, thank you very much for your service for Justice Clarence Thomas with the Judicial Crisis Network and for your wonderful writing. And we'll see you again soon, I'm sure, on Fox News. But for now, again, on behalf of my entire audience, we want to thank you for joining us. It's been very insightful, and we really appreciate your time.
Great to be here.
Orders up. Table 2A.